So another trip into London, another opportunity for a tenuous link carpool case.
Yes, indeed, like I did last time. Another tenuous link. We have just spent a day in Nottingham, which is where I was born, visiting my uncle, celebrating his 80th birthday. Absolutely amazing. So it's all to do with Nottingham. And when I was growing up as a boy in Nottingham, obviously I supported passionately Nottingham Forest, who are doing extremely well this year, of course. And at the time, Nottingham Forest was managed by the late great Brian Clough, legend that he is. And Brian Clough obviously was in charge of the Forest team. And of course, this tenuous link is actually about Brian, not Brian Clough, and actually not even about someone called Brian. Really tenuous link, I'm afraid. This is a case called Robinson versus O'Brien. And even the Brian is spelt with an E, so I'm taking absolute liberties here. So Robinson versus O'Brien, 1973. And it is a landlord case, of course, and we all love landlord, right? So the landlord case here is specifically to do with landlord and tenant, actually. And the law at the time, and still is the case now, is that landlords have a statutory obligation to carry out repairs on properties that are leased to tenants. It's a statutory obligation. But the problem in Robinson and O'Brien was, when does that liability actually start to kick in? When does the clock start to tick on the landlord's liability? So what they said in Robinson and O'Brien is that yes, the landlord does have a duty to carry out those repairs on the exterior, on the structure, on common areas, but until the landlord is on notice that there is a need for repair, the liability does not start in terms of the clock ticking. So the landlord has to be put on notice. What does that mean? It means he either has to have actual notice, or notice kind of inferred or imputed from a third party, like an agent or a plumber or someone like that. But unless, in a nutshell, the landlord knows there is a problem, their liability to repair does not start ticking. As the court said, landlords are not mind readers. They need to know. Now, they don't need to know the extent of the problem. A tenant is not an expert, but they do need to tell the landlord that there is a problem that needs to be fixed. And once that's done, the liability begins. So that's my tenuous case of Robinson